Welcome to Whistle Where You Work. I'm Mark Cohen of the Government Accountability Project. Later in this show, why you don't want to get injured by a medical device. But first, presidents, signing statements, and whistleblowers. On March 11th, President Barack Obama signed a $410 billion omnibus spending bill. But in so doing, he attached a qualifying statement that certain provisions of the legislation raised constitutional concerns, that Congress was stepping on executive powers. One of the specifics he cited was a measure in the bill that would strip a federal manager of their salary if they interfere with communications between a federal employee and Congress. In signing the bill, the president stated he was not waiving his authority to control communications by federal employees involving information that is properly privileged or otherwise confidential. Well, that sounds sensible, but is it? With us to discuss signing statements generally in this particular signing statement are Sharon Bradford Franklin, Senior Counsel at the Constitution Project, and Tom Devine, Legal Director at the Government Accountability Project. Welcome to Whistle Where You Work.
Thank you.
Sharon, let's start with you. Tell us, what are signing statements?
Well, signing statements are something that a president may issue at the time that he signs a bill into law. And signing statements go back to our earliest presidents. Historically, they've been issued over time. And there's nothing inherently wrong or troubling with the mere fact of issuing a signing statement. Historically, though, they were used more for ceremonial purposes, like thanking supporters, or sometimes if a particular piece of legislation seemed ambiguous, the president might set forth his explanation for that legislation. They then started to raise more constitutional concerns with more recent practice, particularly under President Bush. And there's really three types of constitutional issues raised by that use of signing statements. First and most importantly is it's not a question of the mere using a signing statement, it's how it's used. And that's what we're getting at with using the signing statements. And so what President Bush would do in piece of legislation after piece of legislation is cite his objections on a constitutional basis to a piece of legislation and indicate an intention not to enforce it as it was written. And if that legislation was indeed not enforced, that poses the problem where instead of vetoing that legislation, as the Constitution would typically require, and then providing the Congress an opportunity to override the veto, the president was potentially telling the executive branch not to enforce it, but denying Congress that override opportunity. So that's the critical the main constitutional issue raised. Other ones are by engaging this constitutional debate simply by virtue of a signing statement, he is potentially depriving the judiciary from its role of being the final arbiter of our Constitution and what it means and whether a piece of law is indeed constitutional. And finally, it's simply interfering with our respective roles of, the legislature and the president in not engaging on those issues.
But as a practical matter, if a president is faced with a bill, like an omnibus spending bill, with large amounts of money involved, large number of issues taken care of, and the president identifies one or two things in the bill that he or she finds troubling. Does it make sense to veto that bill and send it back for Congress to start all over again? Doesn't a signing statement in that context make sense to avoid the process of duplicative work?
Well, ideally, what would happen in that instance is the president would be aware of that constitutional issue. There is dialogue between the executive and legislative branches as legislation is working its way through the system, particularly on these large appropriations bills. And the president should be able to work with the Congress to identify the constitutional concerns. And if they're valid constitutional concerns and clear constitutional concerns, hopefully through that dialogue they would be able to remedy that provision and avoid having that conflict in the first place. And also, sometimes what happens in a signing statement is the president is flagging a potential constitutional issue. And that may or may not cause us concerns. If he does that rather than sending the bill back, maybe reserving a right. It only really, from our point of view, the Constitution Project raises a constitutional issue if he ultimately directs the executive branch not to implement that legislation as it is written and then denies Congress the opportunity to override or the judiciary to weigh in.
I'd like to come back in a minute to the kinds of signing statements that President Bush implemented that raised so many concerns and talk a little bit about the signing statement on March 11th that President Obama signed. And this was the one that basically sent perhaps a chill to federal employees about exercising their right to take disclosures about wrongdoing to Congress, Tom. Tell me about that.
Well, a signing statement is also a very closely watched measure of the president's attitude towards an issue, whether or not it's enforceable. And President Obama's signing statement could be translated schizophrenically because it was so vague.
What was the language in it that was so vague?
Well, the language is, as you summarized it, that individual employees can't speak for the government in communications with Congress, and that he wasn't waiving his rights against privileged or confidential information.
In other words, that an employee, even if they're not speaking on behalf of the government, if they learn of something in the course of their job duties, if they want to take that information to Congress, if it's declared somehow privileged or confidential, the employee is precluded from doing that?
Well, that's the question. It's long-standing routine. It's not controversial at all that an individual federal worker can't speak for a federal agency, but it's equally ingrained in our system of constitutional rights that they can speak as private citizens to Congress. That's a constitutional right. It's in all of the whistleblower laws, and President Obama didn't draw that distinction.
But surely a federal employee, even speaking on his or her own behalf, can't present classified information to Congress.
Well, that's the other half that needs to be cleared up. An employee does not have the right under the Constitution or any of the whistleblower laws to disclose classified information. It's not written into those laws. And the administration has a valid gripe. All presidents protect their monopoly on the flow of classified information to Congress. But that's not what the signing statement said. It didn't say classified information. It said confidential information. And during the last administration, we've had well over 100 new hybrid secrecy categories created, which I nickname 100 points of darkness. And they're so broad that they could cover virtually anything. They're called sensitive but unclassified, or sensitive security information, or for official use only. And these can cover anything a bureaucrat wants to keep secret. And if that's the case, that individual federal employees, as private citizens, can't blow the whistle to Congress with unclassified information, well, somehow we've linguistically stumbled into an Official Secrets Act. And this would contradict all of his positions on whistleblower rights. It would kind of make a fraud of the transparency cornerstone for this administration. And I don't think that's what they meant. But it needs to be clarified. And these innocuous, broad statements from a president can have a real impact. If I were a federal employee, I would be very wary about opening my mouth in light of the president's remarks.
Sharon, 2 days before President Obama issued this signing statement, he also made a declaration about signing statements generally. Tell us about that.
Well, he issued this proclamation saying how he was going to treat signing statements, well aware of the criticisms of the Bush administration. And he said he was going to do 4 things, and whether or not he will do them, it sounds like Tom thinks he already has failed to do some of them. First, he said that, as I had mentioned before as a possible solution, if he does see a constitutional problem in a bill, he will attempt to redress that with the Congress before that bill is ever passed. Second, he said he will try to really severely narrow and limit the situations in which he does make these types of constitutional objections to where he really feels it's necessary. Third, he said he would be transparent in the exact grounds for what his objection is. It sounds like Tom doesn't feel he was in this case. And fourth, he said whenever he does make this, it will be legitimate. He will only do so when it's well vetted and sound constitutional legal analysis. So these principles are encouraging if he does indeed follow them. But whether they will be carried out remains to be seen.
And are there other indications in any other actions of President Obama to date, like the signing statement on March 11th, that might suggest that he's not going to be completely consistent with that proclamation?
Well, in my understanding, after the signing statements that he issued that Tom was addressing, there have been one more since then, one more provision. And I haven't seen any analysis of that, and I don't know whether he spoke to members of Congress ahead of time or not. I haven't seen any of that tracked.
Tom, what about the president's attitude generally toward whistleblowers? Does this signing statement comport with other steps that the president has taken since he's taken office?
I think it would be very unfair and probably wrong to rush to judgment condemning President Obama's intention here. We can't forget, this is a signing statement that raised some very chilly questions, and it needs to be clarified to be consistent with his other remarks about whistleblower protections and his actions to date. He campaigned as a whistleblower champion. Many officials in his administration have reaffirmed that in generalities. He's appointed some outstanding employee rights advocates to key administration positions so far. But he is sending contradictory signals, and the administration hasn't yet taken a stand on whether it will translate its campaign policies into the government's policies in terms of the real litmus test, the Whistleblower Protection Act. And really we're at a moment of truth for the Obama administration on accountability. They need to take a stand that legislation in the House, which passed unanimously as part of the stimulus but dropped out of the final bill because the Obama administration was silent, that they're supporting this. It would give whistleblowers normal access to court. It would cover all employees funded by the taxpayers. It would upgrade the rights of federal employees to those that Congress has passed about half a dozen times for corporate workers in different sectors over the last 2 years. And it's well past time. We've got record amounts of spending and shovel-ready projects that are ready for corruption because the federal workers are supposed to keep the spending honest, don't dare stick their necks out, and they're getting mixed signals from the president.
Sharon, I'm sure that President Obama does not want to be compared with President Bush when it comes to signing statements and the misuse of them. Tell us a little bit about what people criticize President Bush for in the use of signing statements.
Well, a couple of points. One is the very substance of the nature of the constitutional claims that President Bush was making, with very broad claims of executive power. Some of the standard language in his signing statements talked about him enforcing provisions of law as he saw fit and in compliance with the unitary executive theory, which is a very controversial theory, basically of broad executive powers. Also, President Bush, as people will recall, for a long time never vetoed any legislation that came before him. It was well into his second term before he issued a veto. But each time he would issue a signing statement, and after he had appeared to reach compromise with members of Congress on the legislation, he would then sign these signing statements indicating that he was not going to enforce certain provisions.
In other words, he agreed with the parts he agreed with and wouldn't enforce the parts he didn't agree with.
And Congress didn't necessarily know that. The most famous example, and when this started to come to light, was with the what was called the McCain Amendment, banning the use of torture against detainees. And there was a lot of negotiation. It was highly publicized. Ultimately, the law was passed. President Bush signed it, and simultaneously, but not publicly, he released this signing statement. And as press accounts had it, even Senator McCain was unaware of that at the time. So it's really what the president does with the signing statement. Is he telling his agencies not to enforce it? And there was in 2007 a somewhat limited, but a study by GAO that looked at a sample of 19 of these provisions that President Bush had cited in signing statements. And it found that about 30% of them had actually not been enforced as written by Congress, although they did not analyze whether there was, and did not look to see whether there was any specific direction by the president to the agencies not to enforce them in compliance with the signing statement. So that's really the big question, is what is the president doing after the signing statement? Is he telling his agency officials not to enforce those laws?
So effectively, taken to an extreme, a president could effect an executive coup by the use of signing statements and simply ignoring the will of Congress.
One would hope not, and one would hope that Congress would then step up and enact legislation to try and rectify that and try and get this before a court so we could get back to having the court as the arbiter.
Well, many thanks to Sharon Bradford Franklin of the Constitution Project and Tom Devine of GAP for your thoughts on presidential signing statements and whistleblower rights. Coming up, getting injured twice by medical devices. Welcome back to Whistle Where You Work. Figure this one out. You follow the label directions in taking an FDA-approved prescription drug. It causes a heart attack and, no question, you can sue the drug maker in a state court to recover for your injuries. But if your heart attack is caused by an FDA-approved medical device, like a defective pacemaker, guess what? You can't sue the manufacturer of that device. Period. What is going on here, and what is being done about it? With us to discuss this is Lisa Hayes, Director of Outreach for the Alliance for Justice. Welcome, Lisa, to Whistle Where You Work. Tell us about this weird situation where if you're injured by a medical device, you can't sue about it.
It is a weird decision. It's actually all stems from a 2008 U.S. Supreme Court decision called Regal v. Medtronic. Since 1976, U.S. Americans who have been hurt by medical devices have been able to go into court wherever they live and sue the manufacturer of that device for their injuries. Starting in 2008, the Supreme Court said, in fact, no, you can't sue because the medical device was approved by the Food and Drug Administration, and as a result, any state common law tort claims are preempted.
But we said in the introduction that drugs that are approved by FDA, if they cause injury, people can still sue. What's the difference here?
Well, the difference is two Supreme Court decisions that came down the opposite way. One in 2008 on medical devices, which said you can't sue because of this notion of federal preemption, and one in 2009 having to do with the medical drugs, saying you can go ahead and sue.
All right, that first decision, that was an 8-to-1 decision saying you cannot sue based upon preemption. What's that?
Well, preemption is a topic that some law scholars describe as making their students want to light their hair on fire. It's a complicated discussion, but in a nutshell, preemption means that when the federal government has taken a position on an issue, that the states aren't allowed to intervene with it. The confusion in this case comes from language that Congress put into a statute, saying that because they were passing this FDA approval, state claims were preempted. However, if you talk to members of Congress now, who were actually in Congress when this legislation was passed, they'll tell you what they intended was to preempt states from passing their own safety regulations, not to preempt state tort lawsuits. It's this fine nuance in the law that's confusing by the U.S. Congress and then misinterpreted by the U.S. Supreme Court. And as a result, we're stuck with this crazy conundrum in American law, where if you're hurt by a drug, you can sue. And if you're hurt by your pacemaker or artificial hip, you're out of luck.
So it just comes down to the stray terms or a few words in the medical device law as it currently stands that led the Supreme Court by an 8-to-1 margin to come to a conclusion that was completely at odds with what it concluded in the Levine case regarding drugs.
Exactly, and it's this one word, preemption, this horribly confusing little word that Congress needs to go back and clarify so that both of these Supreme Court decisions would have turned out the same way, protecting American consumers.
Now, you said Congress should go back and fix this. What do they need to do?
Well, right now there's actually pending legislation in Congress called the Medical Device Safety Act. It's been introduced both in the House and in the Senate.
Let me guess, it wasn't introduced by the medical device industry.
No, it wasn't. Representative Waxman and then Senators Leahy and Kennedy on the Senate side. And Representative Pallone has also been an advocate for it on the House side. And they're taking all reasonable steps to move this legislation forward. But what we need to do as the American public is to convince our individual members of Congress that this is a priority, that people are being hurt every day, and that they need to hold hearings in Congress and pass this legislation as quickly as possible.
It really seems like a no-brainer. What's the holdup?
Well, the holdup is, one, this is an issue that doesn't necessarily directly impact a lot of people. So it's difficult to get people's attention. First, you start with that word preemption, and people's eyes glaze over, and then you say medical devices. And if you yourself haven't had a medical device...
Well, what are some medical devices?
Well, you know, I think it's really helpful to look at individual people who've been hurt by this, and that's what I respond to. There's a 2-year-old girl in Illinois who was born with a congenital heart defect, and as a result, she had to have a defibrillator put in her heart. This defibrillator, when she was 3 years old, started going off and shocking her. She's now 5. She's convinced that monsters are coming to get her, still has these horrible nightmares every day because of this defibrillator she had. There's a woman in Maine, a Navy veteran, who was walking through the grocery store one day when her defibrillator went off and literally threw her through the air. You know, she's a veteran, she has insurance, and her personal share of medical bills are over $70,000 that right now she has no recourse for. Pacemakers, artificial hips and limbs. I mean, you can go on through all of these stories all around the country. And
so
meet these
it's not
patients
one
who've
or
been
two
hurt.
people who are affected here. There are quite a few people.
It's thousands of people who've been hurt. And since the Supreme Court decision came down in 2008, literally thousands of lawsuits have been thrown out of courts around the country, telling people who were hurt because they trusted that these devices were safe when they were implanted in their bodies, that they have no recourse and they're out of luck.
So if Congress does revisit this and passes clarifying language that state court suits are not preempted, will those people be able to get back into court?
They will. The proposed legislation, which, by the way, should be a no-brainer. We're talking 2 paragraphs of legislation. It's a third of a page. But it specifically says that Congress never intended to preempt these suits and that it's retroactive, meaning that it will go back to the initial date of enactment of the statute.
And so what's its status right now?
Right now, the bill has been introduced in both the Senate and the House, and we're hoping that hearings will be scheduled before the summer recess so that the bill can keep moving forward.
Now, FDA, where do they come down on all of this? We know that there have been problems in FDA's being a little bit too close to the prescription drug industry, the pharmaceutical companies. They've had some serious problems on the food safety side. Is there a problem about perhaps being a little bit too close as well to the medical device makers? Is that an issue here?
Possibly, but I have a lot of faith in the current administration and in the good career scientists at the FDA, many of whom have gone on the record saying that for 30 years, the tort system and the FDA approval process have worked hand in hand, and that there's no reason that this legislation shouldn't be passed because these tort systems actually help the FDA do their job by putting into public record problems with these medical devices, which makes it easy for the FDA to review them and to update regulations where they need to do so. And the FDA is not alone in that. Groups like the New England Journal of Medicine have also called for passage of this legislation to work with the regulators in actually putting out good products for the American people.
So it was an anomaly that during the Bush administration, the FDA pulled back from its historical position that the civil justice system is a complement to its approval authority as opposed to in lieu of.
Absolutely, and a number of people have gone on the record saying that. And I've hoped that they will now once again come to the helm and take leadership at the FDA and push for passage of this legislation and to keep people safe. What
about the Obama administration? Where are they on all of this?
The Obama administration supports the Medical Device Safety Act, but obviously they're not Congress, so if we can get it through Congress, I have no doubt that the administration will sign the bill into law.
Mm-hmm. And when are you hoping this will happen?
Well, if I had a crystal ball, I would be able to give you a firm answer. We're hoping that it will happen soon, and certainly it needs to happen in 2009. I understand there's pressing issues facing our country, but there are people being hurt every day and lawsuits being thrown out every day, and people who are stuck with medical bills that are mounting and collection agencies coming after them, and we need to give those people relief. So if people will all reach out and take that first step of contacting their member of Congress and telling them to pass the Medical Device Safety Act of 2009, I think we can get this passed within the next few months.
Let's hope so. Many thanks to Lisa Hayes of the Alliance for Justice for spearheading a drive to bring accountability to the medical device industry and some basic fairness to medical device patients. I'm Mark Cohen. See you next time on Whistle Where You Work.
As you heard, I grew up in a law enforcement family. Always thought I wore the white hat, truth, justice, the American way. And I didn't like the fact that I might be doing something illegal. And the more I looked at it, the more I kind of asked around and thought about it. Shortly before I decided to leave, someone said that they are going to shut down the program. Something from the program got into one of the regular application warrants. The sitting attorney general may be indicted for the first time, and the judge that reviews these things is just really upset. And then there was one other characteristic is that my boss, who I really admire, a fellow named James Baker, not the former Secretary of State, would tell us that if we were afraid of putting our name on a warrant on the application, that he would put his name on it. And so I would look at these documents and said, what is he talking about? Why should I be afraid of putting my name on this document? So I put all of those things together. I thought that we were doing something illegal, and I came to the Hill and spoke to an AUSA that I knew, told that AUSA if she could go to the Senate Intelligence Committee or staff, and if the Congress knows what we're doing, then I will just back away. She was never able to tell me that. She came back and said, whistleblowers don't fare very well after they do their act, and you want to be really careful. And so I ended up going to a reporter with the New York Times. And what was interesting was I was the only person from the Department of Justice that they knew of that had kind of had these reservations.